Where is Balake at?
My name's Blake.
Blake? What? Do you want to go to war, Balake? I'm for real. Ron.
Ron is here, everyone. Welcome back for more SPTV, where every day's a great day not to be in a cult, which means it is not a great day for Scientology's tiny little angry leader named David Miscavige. David Miscavige is absolutely melting down and demanding sanctions of at least $5,000. Anyway, at least $5,000 is more like a euphemism for hundreds of thousands of dollars is my best guess. And it's hard to frame this in a way that's quick and easy to understand, but also does the entire thing justice, because there's a number of lawsuits against Scientology. David Miscavige is involved in pretty much all of them. And yet the one that's moving forward the quickest and seems to be the closest to getting little Captain Davy Miscavige under deposition is the one known as Jane Doe versus there's a bunch of defendants, and they're all Scientology individuals and entities. You have Gavin Potter, David Miscavige, Church of Scientology International, Bridge Publications, Religious Technology Center. I'm pretty sure that's all five. Now, what's interesting about what was just filed a couple days ago is this is the first time David Miscavige and his attorneys have actually entered this lawsuit. This is the first time David Miscavige and his attorneys have filed a single motion. And he has, in this motion, at the end of this motion, is a letter from David Miscavige's attorneys complaining that he should not be a part of this lawsuit. It's completely inappropriate. It's completely unethical. It's vexatious. And he wants sanctions, I tell you. Now, you might go, well, why doesn't he file a motion and have himself removed from the lawsuit? And that would be a good question. And the answer is, if he files a motion, this is to the best of my understanding after consulting with some people who know better than I, if he actually files an official motion asking the judge to remove him from a lawsuit, he has to include a declaration from himself. And if he does that, he opens himself up to deposition, and he's still frantically trying to avoid that. I'm going to read for you the letter from Miscavige's attorneys, throwing an absolute hissy fit about all this. But it's interesting because at the same time that he's saying, I shouldn't be involved in this lawsuit and I want sanctions, he's also saying, and I want the right to make Jane Doe, the plaintiff in the lawsuit is a Jane Doe. I want the right to force Jane Doe to sit for an extra day of depositions because my attorneys didn't get a chance to ask her the questions that the Church of Scientology International's attorneys got to ask her. So he's like, I don't want to be in the lawsuit. This is wrong. I want sanctions. But if I have to be in the lawsuit, I want to be able to depose Jane Doe. And it's very interesting. Before I show you the letter, I want to explain how we got to this point and what these depositions are about, because these depositions have to do with it's a very limited scope of deposition. And it has to do with whether Jane Doe was asked, requested, or ordered to destroy any evidence relating to her arbitration agreements or alleged arbitration agreements that may or may not exist with Scientology by a previous attorney she was at one point associated with, had nothing to do with this case, attorney Brian Kent. How did we get here? A number of years ago, another ex-Scientologist named Valeska Paris had joined a lawsuit against Scientology and was for a time represented by now disgraced attorney Brian Kent. Valeska and Brian began a physical relationship with each other. They were both married at the time, but the law doesn't care about that. What the law does care about, though, is that Brian was her attorney before they started their relationship. At one point, I think Brian realized he had gotten way over his head and was potentially in some very deep dog doo-doo. And he basically ended the relationship. And then Valeska got upset, and then she left that attorney, went to another attorney, and then filed a bar complaint, a complaint with the Pennsylvania bar against Brian Kent. Here's the problem. The complaint that was submitted against Brian Kent, based on the information provided by Valeska, said that Brian had asked her to delete text messages between the two of them. Now, he didn't ask her to delete text messages relating to evidence in any case or anything whatsoever, but it said the fact that Brian was asking a client of his to delete evidence of communications between the two of them was mentioned in the complaint that was submitted to the bar. And the complaint that was submitted to the bar contained an extremely irresponsible and generalized accusation that there was reason to believe Brian Kent had asked other clients to delete text messages as well. Whew. Saying something like that in a complaint without just speculating, without providing any details, handed Scientology an absolute bomb that they could use as to weaponize, to harass every other person involved in litigation against Scientology who had ever had anything to do with Brian Kent. Thank God that bar complaint was finally made public just over a year ago, so that everyone currently litigating against Scientology would understand what was out there, what had been alleged, to understand how Scientology would use that, and to prepare appropriately. Because then what happened is Scientology took that unsubstantiated, unverified, unproven, unspecified claim that Brian Kent had, it was believed he had asked other clients to delete text messages. They took that and they went to the judge in this case, Jane Doe against Gavin Potter, David Miscavige, CSI, Bridge Publications, RTC, and said, Your Honor, there has been an allegation that Brian Kent has asked clients to delete messages. What if Brian Kent asked Jane Doe in this case to delete evidence pertaining to the arbitration agreements that may or may not exist, that she may or may not have signed, that may or may not be valid with Scientology? We need to depose Jane Doe about this. And the judge said, okay, we're going to let you depose her on this exact subject, limited scope of deposition. It should take a couple hours, not a big deal. Okay, so then Jane Doe recently had to sit for 7 hours of deposition being asked about Brian Kent and whether Brian Kent had ever asked her to delete messages or evidence, and whether she ever did delete messages or delete evidence. And I'm going to share with you a hilarious portion of the transcript of that deposition, because, well, you'll see why once I share it with you. All of Scientology's attorneys were present. The Church of Scientology International's attorneys were present. David Miscavige's attorneys were present. RTC's attorneys were present. Gavin Potter's attorneys were present. All the attorneys were present. All of them had an opportunity to ask whatever questions that they wanted to. And yet they intentionally chose not to, so that they could then complain that they didn't get a chance to, so that they could then harass Jane Doe 1 with yet another day of depositions. And this is all just Scientology's harassment techniques. It doesn't really amount to a hill of beans. It's not even an effective delay technique, because the trial date for this case is so far in advance that all these shenanigans of trying to harass Jane Doe 1 in this way all these shenanigans and harassments don't actually result in any delay of this thing going to trial. Yes, a trial date has been set. Now it's way far into the future. It might even be 2 years into the future. I don't have the exact date in front of me, but that's how we got to where we are. Okay. And so this is also why, so even in the middle of the deposition that Jane Doe had to sit for, at some point, Miscavige's attorneys did pipe up and is like, we're going to want to ask questions as well. And Jane Doe's attorney was like, well, we're here for 7 hours. You got plenty of opportunity to do so. So please feel free. Because remember, guys, this wasn't just a broad sweeping deposition for all the complaints in the case. It just has to do with whether Brian Kent got her to delete any messages or any evidence relating to anything about arbitration whatsoever. So let me see. What do I want to show you first? The letter from Miscavige's attorney or the hilarious portion of the deposition? I think I'm going to show you the hilarious portion of the deposition first. And I believe this bad boy starts. This is a very, very short section, but it's very, very funny. This starts on page 83. Let me get this properly queued up here, guys. It'll take just a moment. Okay. Now, here's the thing. You guys know there's such a thing as attorney-client privilege, okay? You cannot demand that a client tell you the content of the conversation they had with their attorney. And that fact is what is behind this hilarious portion of the deposition. All right, here we go. Check this out. Okay. By the way, Bill Foreman is representing Church of Scientology International. He's the one doing the questioning. Okay. Bill Foreman says, I wanted to return to Brian Kent for a little bit. Jana says, okay. So in March of 2022, Mr. Kent was no longer your lawyer, correct? She says, I believe that's correct. Okay. And that was about 2 years after you signed the 2020 declaration. By the way, the declaration being referred to here is the declaration Jane Doe filled out about the subject of her Scientology arbitration agreements that may or may not be signed or may not be valid. Okay, so that was about 2 years after you signed the 2020 declaration. You were the first of the Bixler plaintiffs to change lawyers, as far as I recall. Is that correct? Again, this is referring to the fact that Brian Kent was representing a whole bunch of Scientologists in a whole bunch of different cases. And one of the cases he was involved in is another case that this Jane Doe is also involved in, known as the Bixler lawsuit. And gradually, pretty much everyone dumped Brian Kent, and that's what's being referred to here. Okay, you were the first of the Bixler plaintiffs to change lawyers, as far as I recall. Is that correct? She says, I can't be certain, but I think that is correct. It's your recollection that you got rid of Brian Kent before the others did. I think I can say that. Okay, did you actually dismiss Brian Kent? Did you fire him? She says, yeah. She goes, and Miss Parrish is Jane Doe's attorney. Objection calls for attorney-client communications. Oh, wait. Did I miss a question here? So she answered. So the client answered the question before the attorney jumped in. Objection calls for attorney-client communications. I instruct you not to answer. Witness says, okay. Bill Foreman, well, I think the destruction of documents related to the lawsuit would be subject to the client product exception. Jane Doe's attorney says, counsel, it's a matter of rephrasing. You can ask about the underlying conduct if documents were destroyed, just not if she's instructed to by her attorneys, if that's fair. Mr. Foreman, well, I think the asking is important, meaning Brian Kent asking to destroy things. Well, I think the asking is important because the asking is itself criminal or is a fraud on the court by a lawyer. And Jane Doe says, is he talking to you or me? And the lawyer says, I'm talking to her. And she says, okay. Mr. Foreman goes, yeah, so I'm just going to ask you again. Did Mr. Kent ever ask you to destroy or delete any documents? Objection calls for attorney-client privilege. I instruct you not to answer. You can rephrase your question to ask about conduct, but not the communication. And the witness says, okay, I'm going to listen to her, my lawyer, but I think you could rephrase it and I can answer what you're trying to ask. Okay, Mr. Foreman, I'm not sure I can rephrase it. I'm looking for whether Mr. Kent instructed people to do this. And I don't think that's subject to the privilege. It falls within the crime fraud exception. Jane Doe's attorney, it would fall into the crime fraud exception if there was a prima facie, I never know if that's the right way to pronounce that word. If there was a prima facie case that there was a fraud committed, but we have not established that there was any evidence destroyed, so you cannot break attorney-client privilege. I find this stuff totally fascinating. So my understanding of this, and I've checked with others, is that if it had already been proven or stipulated that evidence was destroyed, you could then ask whether that destruction was requested or ordered by the attorney. But short of any evidence that any evidence was destroyed, you cannot ask about the conversation without breaking attorney-client privilege. Okay. Okay, Mr. Foreman goes, it's not based on evidence destroyed. It's also based on improper conduct by an attorney trying to put a fraud on the court. Jane Doe's attorney says, okay, well, then that's a question that you can ask Mr. Kent about. Jane Doe says, I mean, what if you ask me if I have any reason at all to believe he did? I could answer that, right? And her attorney goes, we don't have to help him. Okay. And then Mr. Foreman goes, okay. And that's where the deposition ends. This is where everything stood when literally the clock struck 7 hours. My understanding is that in California, there's some legal thing. 7 hours is all you are. 7 hours of actually sitting in the chair on the record, under oath or whatever, however it is the most you have to be subjected to a deposition in a single day. So realize, guys, the limited scope of this deposition was simply and only to ask about Brian Kent and the possible destruction of evidence, even though Brian Kent never represented Jane Doe in this case ever. Brian Kent was not representing Jane Doe in any case whatsoever when she brought this case. It's all gamesmanship. It's absolutely nothing but gamesmanship. Okay, so let's jump down all the way to the letter from little Captain Davy of the fake Space Navy's attorney. And we're not going to read this whole letter as well, because my God, do they like to be wordy about all of this. Okay, we got it set up there. David Miscavige actually has two attorneys, one by the name of Alex Weingarten and one by the name of Jeffrey Riffer. And this is, in fact, the first motion either of those attorneys have ever submitted in this case. It's pretty noteworthy that Miscavige is finally rearing his tiny little head in this case. Okay, let's take a look at this, because I actually have to get out of here pretty quickly, but we're going to do our best to cover as much of this as we can that actually matters. Okay, regarding anticipated motion to compel second session of plaintiff Jane Doe's deposition and request for monetary sanctions. I write on behalf of defendant David Miscavige pursuant to California Civil Procedure Code, blah, 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 to meet and confer regarding Mr. Miscavige's anticipated motion to compel the second session of plaintiff Jane Doe's deposition and request for monetary sanctions. Doe voluntarily chose to name numerous purported defendants who have nothing to do with her primary dispute with her ex-husband, Gavin Potter, and who are all entitled to defend themselves. However, Doe refused to allow Mr. Miscavige to ask questions at the first session of her court-ordered deposition, despite her insistence on pursuing frivolous litigation against him. As such, Mr. Miscavige intends to file a motion seeking an order, 1, compelling Doe to sit for a second session of her deposition to allow his counsel to ask questions regarding arbitration, and 2, requiring Doe and Doe's counsel to pay monetary sanctions should Doe refuse to withdraw her scurrilous claims against Mr. Miscavige and continue to obstruct his ability to defend himself by refusing to sit for a second deposition. Okay, now here's what slightly confuses me about this sentence, and I want your guys' opinion as to whether I'm understanding the sentence correctly. The motion, or the motion, because remember, this is a letter. This is a letter at the end of the motion. This was a letter sent to Jane Doe and her team well in advance of filing this motion. It's basically a threat. It's basically, I'm considering a threat of, this is what we're planning on doing, and you have an opportunity to let us not, you have an opportunity to allow us to pursue an alternate route. So I'm going to ask her to sit for a second arbitration, and I'm going to ask Doe and her team to pay sanctions should she refuse to withdraw her scurrilous claims. Okay. So you're giving her an opportunity to voluntarily dismiss Miscavige from the lawsuit, but you're doing that at the same time that you're demanding she sit for a second day of deposition. And at the same time, you're complaining that she's, anyway, it doesn't seem like this fits. Anyway, I won't beat it to death. It's just, I'm curious to know what you guys think about this sentence. Does it make sense? Okay, Doe's litigation against Mr. Miscavige is a sham orchestrated by a vexatious, litigant. There has never been a legal or factual basis for Doe to drag the ecclesiastical leader of a worldwide religion into a lawsuit concocted by a disgraced and vexatious lawyer, Graham Barry. On December 29th, 2022, Barry signed and filed a complaint and certificate of merit against Mr. Miscavige on Doe's behalf, despite having zero personal knowledge of any of the allegations contained in the complaint or certificate of merit. Graham Barry's complaint contains zero allegations of any wrongdoing by Mr. Miscavige, despite asserting 6 claims against him. Okay, and this is where things start to get really, really, really wordy. And I honestly, I'm not going through it. I'm not going to go through it. So let me, first of all, it seems like there's really no one on earth David Miscavige hates more than Graham Barry. Attorney Graham Barry has been involved in litigation against Scientology for decades and decades now. He's actually been, over the time period, one of the more successful attorneys and extremely successful in recent years in helping certain ex-Scientologists actually get refunds and repayments from Scientology, particularly when they are senior citizens. Elder abuse is something that, believe it or not, religious protections do not shield you against. So, okay, let's see. I want to go to one of the sections where he's really throwing a tantrum. All right, here, let's just jump to this. Doe should drop her claims to avoid terminating and monetary sanctions. On September 16th, 2024, Mr. Miscavige served the sanctions motions seeking terminating and monetary sanctions. The sanctions motions provides evidence to show that Barry did not plead any factual allegations to support Doe's claim against Mr. Miscavige, and that neither Doe nor any of her counsel could allege any facts. The sanctions motion also cites authority that conclusively shows there's no legal basis to pursue a claim against Mr. Miscavige. Doe and her counsel could not provide a single citation to authority or evidence to defend their conduct in response to the sanctions motion, despite having half a year to step forward with such evidence or law if it exists, and an obligation to conduct a pre-filing investigation and or an investigation when becoming counsel. Well, geez, if you feel so strongly about it, why don't you file a motion asking yourself to be dismissed from the lawsuit? Like, it's so absurdly silly. It seems, based on this letter, it seems that behind the scenes, Miscavige has been throwing an absolute bitch fit with all sorts of threats, monetary threats, all sorts of stuff, basically trying to threaten and coerce, but also beg and plead that the plaintiffs voluntarily dismiss David Miscavige from the lawsuit. It's like, yeah, we all know why you don't want to officially file a motion asking. We know why you don't want to provide your own declaration to the court. I absolutely love seeing him squirm in this way. Okay, let's see. All right, fine. We'll just read this part. We're going to wrap this up soon. We'll go through some starred comments and wrap it up. Doe cannot prohibit Mr. Miscavige from participating in discovery if she insists on maintaining her meritless litigation against him. Mr. Miscavige must have an opportunity to participate in and ask questions at Doe's court-ordered deposition. If Doe refuses to drop her manufactured claims against him, due process requires that Mr. Miscavige have an opportunity to depose Doe regarding arbitration issues as provided for in the court's order. Now, this is interesting because at some point here, they actually misquote the judge. Let me see here. Okay, Doe chose to duplicate these proceedings by naming numerous defendants. Doe cannot claim that she will only sit for a total of 7 hours of deposition, providing approximately 1 hour for each defendant to ask questions. Doe must give each defendant an opportunity to fairly examine her if she insists on pursuing her duplicative claims. The court already identified this issue and recognized the defendants likely will need more than 7 hours to depose Doe regarding arbitration. Oh, and this is where they misquote the judge. Quote, I mean, she's the plaintiff. I would think her deposition is probably going to last more than, could easily last more than a whole day. They already know that they are misquoting. They're taking a quote out of context from the previous meeting where the goings on of this deposition were being discussed. There were some, I don't think I'm going to use the right phrase, but there were some like medical allowances being requested I don't know what the right phrase is. There was a concern that the deposition may not be able to comfortably go on for more than 2 hours. And the judge had basically said, if you get to the 2-hour point and it hasn't been resolved yet, and it hasn't been resolved yet, and Jane Doe isn't able to keep going after 2 hours, then we can revisit this and maybe it can go on for a second day. But the truth is, see, Scientology is trying to argue that the judge has already said this should probably be expected to go on for multiple days. And yet the reason Scientology is having to file this motion is because the judge didn't authorize more than 1 day. It's a little weird to use the judge's own words against Jane Doe when the only reason Jane Doe even had the right to not continue to sit for additional days is because the judge had not ordered it. The whole thing is just a little weird and shifty. Okay, let's see if there's anything more. Oh, look. Yes, Scientology continues to claim, well, David Miscavige's attorneys continue to claim that they should be able to ask Jane Doe, and Jane Doe should be compelled to answer questions about what her attorney told her. Even though it's already been established, she's already answered the question in the deposition that she did not destroy any text messages or evidence whatsoever. But Miscavige, see, that's not good enough for their attorneys. They're not willing to just accept the limited scope of the deposition. No evidence was destroyed. No text messages were deleted. They really want to know, but did Brian Kent ever ask you to? And it really would violate attorney-client privilege to answer that question. So anyway, here's just document of their thoughts on this. The attorney-client privilege does not shield Doe from answering questions about discussions she had with her attorney regarding submitting false testimony to the court and spoiling evidence. Yeah, that's pretty much it. Let me see. Quickly scrolling through here if there's anything else I want to touch on. Well, okay, here's just a reiteration of the sanctions. Mr. Miscavige intends to seek at least $5,000 in monetary sanctions against Doe and her counsel for Doe's misuses of the discovery process. Doe wasted time at her deposition by refusing to provide straightforward answers to straightforward questions. Doe then refused to proceed a minute past 7 hours to allow Mr. Miscavige or other defendants an opportunity to ask questions, despite running down the clock with evasive answers. And despite the court's acknowledgement that the deposition would require more than 7 hours, additionally, sanctions are warranted in light of Doe's repeated unsuccessful attempts to avoid her deposition and refusal to cooperate at the court-ordered deposition. See, this is all just silliness. Absolute silliness. Oh, and here he is crying that he shouldn't be in the lawsuit anyway. There's no basis for Doe or her counsel to continue to pursue claims against Mr. Miscavige, and any further refusal to withdraw the claims against Mr. Miscavige further supports issuing terminating and monetary sanctions. Moreover, there is no basis for Doe to refuse to sit for a second session of her deposition to allow Mr. Miscavige to ask questions regarding arbitration if Doe insists on continuing her witch hunt. Exactly. Jane Doe is orchestrating a witch hunt against David Miscavige. Doe should file for a request for dismissal with prejudice. Alternatively, please let us know when you are available for a call to discuss issues identified herein on or before March 28th. There you go. Crybaby, little Captain Davy, the fake Space Navy, throwing an absolute hissy fit that he's having to be dragged into this lawsuit. This is not going to go well for David Miscavige, is my prediction. Okay, let's just go through a handful of starred comments, and I have to get out of here. Let's see. Oh, Jojo says, the way Americans say Graham blows my mind. In England, we say it like Graham. Oh, yeah, we don't say Graham. We do not say Graham. Okay, hold on. What is this? Liz Gail, good to see you. Ridiculous David Miscavige. Eunice Swag Pants. Does little Captain Davy pay his lawyers by the word or what? Holy guacamole. Yeah. Rochelle says, I imagine David was kicking and screaming on the floor because he may have to appear in public. I mean, appearing in public is one thing, but way before he ever has to appear in public, he has to sit for a deposition. Oh, maybe that's what you mean by appearing in public. I think appearing in public to actually be showing up in court. But I'll tell you, David Miscavige having to sit. I mean, in fact, here's the thing. I think this entire motion itself may, in fact, David Miscavige may open him up right now to deposition, in my opinion. There is a reference buried in this filing that I didn't have any reason to specifically share with you. There's a reference made to a form they are claiming Jane Doe signed with respect to working for David Miscavige. And that form and any information surrounding it would be something that David Miscavige should have some personal knowledge of. And I mean, that right there might be an opportunity to be like, well, I mean, Your Honor. What if it was like this? We totally agree that David Miscavige's attorneys should have an opportunity to have Jane Doe sit for another 7 hours. And we also think that we also need an opportunity to have him sit for 7 hours as well. I swear to God, I think there's a really good chance that that's the way this goes. That's one of the reasons I'm so freaking excited about it. All right, let's see. Lydia Von Stretchclaw, so good to see you. Davey is so bitter he can't get Jane Doe into a committee of evidence. New England Truth says they're losing the war. It certainly feels that way, doesn't it? And speaking of that, the reason I got to get out of here is because the Clearwater crew and I are having our weekly Friday night protest in downtown Clearwater, across from the Fort Harrison Hotel. Anybody and everybody that can make it is free to join us. If you can't join us in person or you can't drive by and give us a honk, maybe you can just join us in the live chat. Before we go, I do have a fun little thing that I promised I would do to one of the most long-term and active members of the live chat, Abigail. I want to make sure I pronounce your last name correctly, because Sunoth. Abigail Sunoth. If you guys have been in the live chat, you guys all know her. You guys have all seen her. You guys all love her. Abigail's father has just recently written a book, and I told her that I would mention it to you guys. So check this out. Her father, Sankar, apologies if I'm not emphasizing the right part of the name, Sankar Sunoth. Check this out. This is on Amazon, guys. An Improbable Life, an immigrant's journey to CEO and the American dream. How one immigrant built a $300 million success story from third world beginnings. You can get this book on Amazon for $20. I thought that was really awesome, and I promised I would share. And so there you go. Let's see. What else, guys? Have I missed anything? One last check. Okay, Rochelle asks, different case, but do you know what happened with the Mills case on May 1st? I know you left for Hawaii that day. Whatever happened, it wasn't groundbreaking. Either way, the case is still going forward. And the next time there's an update, I'll do a proper video about it. All right, everyone, that's all I got for now. Heading downtown, join us for the live stream protest. After the protest, we're going to head over to Prelude Sports Bar, downtown Clearwater on Cleveland Street. Anyone can feel free to join us there. See you guys soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,